The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. 3 cases will be submitted this afternoon. Those cases are Oyens Feed and Supply versus Primebank, Des Moines Flying Service, Inc. versus Aerial Service, Inc. and others. And the final case is in re the marriage of Angela Marie Harris and Patrick David Harris. The last case is now submitted to the court without argument, and we'll hear the arguments in the first case, Oyens Feed and Supply. Mr. Voss.
May it please the court, opposing counsel. This is the second time that this court has received certified questions in this bankruptcy case. 4 years ago, the court was asked to interpret whether a feed dealer's lien priority was dependent on whether it had submitted a certified notice under 578.2, and this court determined, based on the language of 578.5, that a feed dealer's priority was not dependent on sending such a certified notice. Now, after trial, this court is asked to resolve 2 final questions of statutory interpretation. The first question is whether a feed supplier is required to give notice every 31 days in order to maintain its priority. And the second question is whether livestock that is raised by a farmer from birth has an acquisition price. The bankruptcy court determined under its reading of 578.4 that the lien had to be refiled every 31 days. As a result, the bankruptcy court found a gap in perfection on the part of Oyens Feed to the tune of about $186,000 over feed supplied in a 45-day period. The bankruptcy court also determined that the farmer, in this case, had paid no acquisition price for the livestock which had been raised from birth. Following the bankruptcy court's decision, both sides appealed and cross-appealed to the United States District Court for Northern District of Iowa, and that court then certified these 2 questions here. And so as we begin with this 578.4 filing issue, we begin with the statutory language. That code section provides that in order to perfect the lien, the ag supply dealer must file a financing statement within 31 days after the date the farmer purchases the agricultural supply. The initial threshold question that we're fighting over is whether that statute is ambiguous, whether in this case within means during a discrete 31-day period, or whether within simply means not later than and fixed is the last date by which the statutory lien can be filed. Judge Collins looked at the statute and said within 31 days after means during, and that was that is one meaning of the word within, but for 3 main reasons, we don't think that's the correct interpretation that should have been applied by the court here. Initially, the Jensen versus Nelson case and other Iowa cases have noted that within sometimes fixes only the ending of a period and means not later than or before the expiration of. And either of those definitions, if applied here, would have made the first filing by Oyens Feed on May 28, 2009 sufficient to perfect future deliveries of feed. When we look back at the history of the statute, prior to 2003, when the statute was changed to conform with revised Article 9, it is clear that the statute allowed filing a lien to perfect future deliveries of feed. We see that 2 ways. In the prior version of 578.4, the lien statement was to be filed indicating the amount of feed which has been or may be purchased, and the may be purchased language referred to future purchases that had not occurred yet. And so it was clear, and Judge Collins acknowledged that in his prior writing in the Shalista case on this same issue, that before the 2003 amendment, you could perfect as to future feed liens, future feed deliveries. Additionally, the prior version of 578.4 noted that filing was permissible at the time of purchase or delivery, but not later than 31 days after the first date that payment was due. And so under the prior version, you were allowed to file at the time that the feed was purchased or delivered, and the not later than language just confirmed that there was a final date after which you couldn't file, but it didn't set a beginning date for the filing. And so Judge Collins in his prior decisions had acknowledged all of that, but then he asserted that when the language was revised in 2003 to conform with revised Article 9, that this language was lost and that he had to presume that the legislature intended to change the meaning of the statute. And that's...
Ask a question.
Yep.
Is there any other area where if you have a lien that is perfected by central filing with the Secretary of State's office and there's sort of an ongoing business relationship between the parties, you have to make a filing this often, if assuming the other side's interpretation is right, where you'd have to be filing every month with the Secretary of State's office? Does that scenario arise anywhere else?
None that I'm aware of, Your Honor. You know, some of these ag liens do require periodic filings. For example, if you're dealing with a commodity production lien or a custom cattle feedlot lien where you've got continuous arrival of cattle, then you have to file every 180 days, but there's nothing that requires every 31 days like this. And so
And how long would the lien then, under your interpretation, remain?
well, the lien the lien would remain out there. The lapse date for a financing statement is 5 years, but the lien, in this case, 578.3, limits the lien to cattle that are consuming the lien, and so you have that sort of natural limitation on the life of the lien that in the case of hogs, you know, you're turning over a couple of different turns a year, and so you kind of...
So how would that notice work to a potential creditor to understand whether or not that would be collateral that they should stay away from?
Sure. Well, the way it works, or typically is working right now, is when you file your lien statement, the typical practice is that your lien statement indicates the barns or locations where the animals are located, and so that's what happens in the lien filings that are in the record. In this case, it indicated the particular barns, and so it does require an additional step by the lender to check, but the lender can check, well, what's the relationship between when the lien was filed and then when that barn would have emptied out and the next turn of pigs went in. So it's...
Would that require just checking with the Secretary of State, or would they need to take a visit to the farm?
That would require checking with the farmer. But I think in the amicus brief has already acknowledged, I think, that the consequence of this court's 2011 decision means that they have to monitor more closely, and that I don't think it's a burdensome thing to check with your borrower to say, you know, what's the status of your barns? When did the animals come in? When did they empty out? So I think that's the limitation, is that you have the 578.3 language that limits the lien to livestock that are consuming the feed.
How burdensome is it to do the monthly filing? Can that be done electronically?
It is done electronically. It's a monthly filing with the Secretary of State if this court determines that monthly filing is required. It's a financing statement, and it's possible. It's just a question of whether the legislature intended this. And when you look at the legislative intent from 2003, what the legislature indicated was that they were revising the statute to conform with revised Article 9, to eliminate filing requirements that were inconsistent with revised Article 9, and that they were maintaining the priority scheme that these liens enjoyed prior to the adoption of revised Article 9. And so that's where, when you look at Judge Collins's decisions, where, in my opinion, he goes off track, is that he says we have to presume that the 2003 amendments were a substantive change. And I think you look at the legislative history that's available, and the legislature intended nothing of the sort. They understood that revised Article 9 had happened, and now these liens were within the perfection scheme of revised Article 9, but they wanted to maintain the priority that the liens enjoyed beforehand, rather than making a substantive change. And so that's where Judge Collins, I think, got off track in Shalista, and then he repeats that same analysis through his other cases, including this one.
I don't have any knowledge of hog raising, but if we're talking about a barn and you're saying that it's incumbent upon the lender, then the other lender, to go out and do their due diligence, these have literally hundreds and hundreds of hogs in them, don't they?
Yeah.
Are they all at the same age, all at the same time? I mean, how are you going to make that determination?
Sure.
I see these big buildings, and I don't know if they're all exactly the same age, or if you take them all to market at the same time. That seems like it's a real
Sure. And that's
workable solution.
That's a fair question. Typically, your finishing barns, which will have either hogs that are beginning when they're just weaned, in which case they're called iso-weaned and they're about 3 weeks old, or they'll start with feeder pigs, which would be about 8 weeks old. In either instance, you put a whole load of pigs the same age in the barn, and the barn empties out basically at the same time, and then you put a new turn of pigs in. And so there typically is not an intermingling of ages within a barn. The other issue that is raised by 578.4 is that the statute itself says that the lien is to be perfected as provided in section 554.9308. And that subsection, there's a subsection of that, subsection 2, which deals with agricultural liens. And in relevant part, it states that an agricultural lien is perfected when it becomes effective if the applicable requirements are satisfied before the agricultural lien becomes effective. And that's a lot of gibberish, perhaps, but with a feed lien, the effective date is when the feed is purchased, and this statute then allows the applicable requirements, which is filing a financing statement, to be done before the lien becomes effective. That rule is incorporated into 578.4 by specific reference, and that is consistent then with the prior version of the statute, which allowed you to file the lien at the time it became at the time the feed was purchased or delivered. And so section 9308 subsection 2 also would be consistent with allowing you to file in advance at the time the feed is delivered.
The bank suggests you don't need to file monthly, or one way to avoid that would be to just deliver a bigger quantity, deliver a 6-month or a year supply. Could you respond to that? Is that a practical?
You're going to be limited by the size of the grain elevator, so to speak, mini elevator there that is going to have X tons of capacity. So you can't deliver a year's supply at one time. The amicus suggested that you could enter into a longer-term supply contract and say, here's our contract to purchase 2 years of feed, and then you could perfect that by a single filing, which, in my mind, completely overrides their assertion that you need a bright line rule, because then you're right back to having to do this kind of farmer-specific inquiry as to what sort of contract did you enter into, and is it a contract that you can perfect then for multiple years or not? So that the amicus is, just doesn't provide any additional certainty in that manner.
Well, how often are we talking about delivering of the grain in this case? Were there 3 separate and isolated deliveries of grain? Because my point is, or I guess where I'm going with that is, what's so difficult if you're going out and delivering tons of grain once every month or once every 45 days, whatever the case may be, of simply saying, you deliver the grain, then somebody ought to be filing a financing statement.
It's much quicker than that. There literally were hundreds of deliveries in that 45-day period, and so when you're talking on about this scale of production, you are literally talking about hundreds of deliveries to every site of 10, 20 tons, of feed a couple times a week. So there's a dramatic amount of feed being delivered.
Thank you, Mr. Voss. Mr. Sandberg. And welcome.
Thank you. Thank you for welcoming me to this court and to your state. May it please the court and opposing counsel, both questions before this court are easily and correctly and necessarily answered with nothing more than the plain language of the 2 statutes at issue. If one were to catalog every principle and maxim of statutory construction articulated by this court, one would stand out as the most frequently and readily employed. That is, that legislative intent is gleaned first and foremost from the language of the statute. What this means is the court does not search for meaning beyond the plain language of the statute if the meaning is clear. It does not resort to principles of statutory construction if the language is plain and the meaning is clear. And it does not contrive confusion or ambiguity with hypothetical fact patterns or grammatical niceties. Statutory words are presumed to have their plain and ordinary meaning, and this court gives full effect to each provision and term in the statute. It doesn't cherry pick or ignore or selectively apply terms. These are the fundamentals, and unlike almost every other issue raised by my opponents in this case, it took me very little time and virtually no research to assemble those principles in the brief because they are articulated over and over by this court. And why is that? Well, from a practical perspective, most statutes are like the statutes here. They are plainly worded, they use clear language, and they're without riddles or double entendres. But this court articulates and enforces these mandates for another reason. The legislature, in enacting these 2 statutes, considered the needs of all the players and constituents: the farmer, the feed dealer, the lender, the end user. And we may not like the way the legislature intermediates these concerns. Some players are favored over others, burdens are imposed, and common sense and practicality does not always come first. But one of the reasons this court, like almost all courts, have the plain language fundamental rule for statutory construction is to respect the process and that branch of government.
Let me ask you a practical question. I understand your argument that after means after, and there's a certain amount of force to that argument, but from a practical perspective, as the bank, if you do the UCC search and you find out that there's one of these financing statements filed against your debtor by an agricultural supplier, at that point you're going to have a conversation with your borrower anyway. I mean, what's the difference between whether the statements have to be filed every 31 days or every 180 days or whenever? Am I wrong about that?
No, and I think different banks would approach that differently based on the circumstance of the borrower and what the added filings tell the lender and the public at large is, how often is this coming up? Is the feed dealer comfortable enough that it's going to get paid, that it's just going to perfect this for the last 31 days, or is this an ongoing problem? Is there some kind of crisis that's going on 60, 90, or more time than that? And that is one of the, in addition to the plain language, there are some facets of these statutes.
Why would the legislature want this perfected every 31 days after delivery, each and every delivery? What are the policy reasons for it?
Well, one of the things that everyone agrees on about this is that what these statutes address is adding value in times of crisis. If a feed dealer had to rely on liens rather than just timely payment to get paid, there would be no feed dealers. This statute was born out of a crisis in the 1980s. And when there is a crisis, everyone is more vigilant. You're probably not just checking on your security and how you've secured that and your creditor or your debtor's ability to pay monthly. You're checking on it daily. And that when you don't always understand the dealings or the machinations of the dealings between a farmer and his feed dealer, in this particular case, they were close friends, they didn't have a contract. It's very difficult for a remote lender, especially one who's out of state, which is a class of lender completely blocked out of lending if you're saying they have to have a presence here to go check on the farm. But for them to know what's going on, and it's not a perfect way, and you can come up with a lot of hypotheticals and practical situations where it may not work. It's the best way the legislature resolved to tell a lender, this is what's going on and how often this is occurring.
If the feed dealer has an obligation to file these every 31 days, what is the obligation to release these liens?
Well, there is no obligation to release the liens that's one of the useful practical facets of the way the plain language is written, is it's gone after, within 31 days. And so the time period. It adds some level of predictability to this. I do want to address the relative burdens here on the parties. The court asked how difficult this is to do this every 31 days. And make no mistake, it is a matter of a few minutes and a mouse click. I checked that this morning. I could do it on my phone if I had to, and I'm not very technically adept. It is not a serious burden on anyone. And when you're talking about having to have someone go out when you don't know how many hogs were at a facility at a given time when grain was delivered, when it was delivered, whether it was stored or immediately fed, and having to go out and check on that with a remote borrower farmer, that is a much more serious burden. It should also be noted that banks don't have the monopoly on the UCC security interests that the bank in this case had. If it's important enough for a feed dealer, they can ask their customers to execute a continuing blanket lien like the bank had, and that's not a statutory term. That is a matter of contract between the parties. All the statute says is if you have that, it's first in time, first in right, with some very narrow exceptions. But the vast majority of feed dealers are not lenders, and the vast majority of feed purchases are paid after the sale. It's
Just
tempting-
clarify for me just a little bit, maybe the facts, just so I can understand it a little bit better. So Primebank has they have $1 million lien or something against this property. And am I correct that during this gap period, I'm going to refer to it as a gap period because we're arguing about $186,000 here, was money expended by Primebank during this interim period or during this gap period? Or is this all relate back to a previous one where you're now saying, well, kind of gotcha, we've got this gap period, and now we don't want you to have a super priority in that gap period because you didn't follow the 31 days?
Well, my understanding is, in this particular case, is that there wasn't money being advanced during that gap period, and whether or not that's true, that is precisely how this could play out. Lenders don't just advance money for feed costs. They don't, they certainly, that's part of what gets paid with lenders' money, but they advance millions of dollars, which has not been repaid and is racked up to fund a farm's entire operations. And feed dealers are far from the only party to feel the sting when a crisis comes on. They get this super priority. They get the gotcha moment, frankly, on this. They get to say, we get to jump ahead of you and all the money that you already advanced, and we get to jump ahead of your contract, and we get to jump ahead of your of the statute. And that is what the legislature provides under certain circumstances, but it does not and provide in the plain language, nor should the plain language be construed to provide some kind of continuing lien that goes on, and nor should it be provide, you know, a blanket lien that covers the entirety of a herd of livestock. It should be applied according to the plain language. It's tempting to assume, I'd like to note in these kind of situations, that lenders are these big mega corporations that are much able to absorb the kind of losses that come in these crises that the statute was written for. That assumption is not supported or not allowed to be indulged by the plain language, but it's also flawed. My client is a small family-owned bank with 3 branches in Lamar's and Sioux City that has employees that depend on the recovery of loaned funds to get their paycheck. I would urge the court to read footnote 11 of the amicus brief with the Fifth Circuit decision that can show that assumption, that David and Goliath assumption, can very often be turned on its head. As far as the acquisition value at issue here, and the burdens associated with that, I will readily concede that showing that is a more burdensome undertaking than going online and doing a few mouse clicks, and that every part of that formula that this court has tied directly to the benefit that feed dealers get, their ability with this super priority. This court, in the first time all these parties were in front of it, noted that one of the reasons that the court ruled the way it did as far as not requiring the certified notice and the actual priority is because there's this corresponding burden, this formula. Every aspect of that formula requires some knowledge and involvement in the farmer's operation. And I do not envy the feed dealer, the remote and independent feed dealer, who has to go and figure out what the sale price was or the market value of the livestock was at the time the lien attached. That may not always be information that is directly at the feed dealer's disposal, but those are...
Question about that. Your position, so is it your position that if the hog farmer acquires the livestock from some other third party, purchases them from some third party, no matter how young they are and no matter how low the price, we use that as the acquisition price?
Yes, that is the acquisition price.
But then if it's a true farrow to finish operation and they raise them themselves, then you can add in all these other costs that might be much greater than the acquisition price if they were purchased at a very young age from a third party. Isn't that kind of inconsistent?
Well, the hypothetical you pose could play out that way, and it would be inconsistent, or it could play out the complete opposite. There are a lot of variables that go into the price of acquiring an already born hog, and there's a lot of variables that go into the acquisition value of a hog that is raised farrow to finish, and that it's not a perfect statute. It's not a perfect check on this super priority. It's the one that the legislature has prescribed.
I'm moving by your, for now, the plain language argument to the statutory history argument that's been advanced by your opponent. The suggestion is that the bankruptcy court relied on a principle of construction that ordinarily the legislature, when it amends something, intends to make a change, and I think there's case law that supports that. On the other hand, from time to time, you know, kind of the legislature does engage in clarifications and overhauls that don't necessarily change substantive statutes. And the suggestion has been made that if we really look at this in context, this was more akin to a clarification than any kind of substantive change. Why don't you address that argument, please?
Sure. There were a lot of changes in the 2-3 language and the language we have now.
I could argue, I mean, you look at it, on the surface, it looks like a kind of a overhaul operation.
Yeah, yes, and there's some stark differences. It would be our position that the bankruptcy court did not rely on that as the basis for its decision. It spent more time on it because it was indulging arguments, but it was dicta in the bankruptcy court's opinion. But that, you know, setting the bankruptcy court's reasoning aside and just looking at the statute, I think nothing in the plain language of the pre-existing statute or the post-statute or, you know, the legislative commentary or hearing notes or anything of which there's none, it supports an idea that somehow a lien filed more than 31 days after the within period is still effective in light of that. I think as tempting as it is, and it would take a lot of wordsmithing and looking back and forth at the two statutes to support either a view in my favor or
It might even be both. I mean, it might be a clarification and a substantive change. I mean, of course,
it could be both, or it could be neither, or it could be any number of things. And it's I hate to bring it back to my original point, but it is the reason why plain language is so important and so favored by this court. Thank you all very much.
Thank you as well, counsel. Rebuttal?
Thank you, Your Honor. I wanted to touch on acquisition price because the bankruptcy court was not misled. It looked at what was being proposed as a definition of acquisition price that included overhead and direct and indirect costs of production, and said the legislature had to mean something different than operating expenses. It said acquisition price, and so it simply rejected the idea that you have to calculate all of the overhead expenses, direct, indirect expenses, and include all of those in some sort of formula as to what the acquisition price would be. And there's a couple of things that if you just try and play through it, demonstrates how unworkable that would be. First is if you're calculating your acquisition price to include all of the costs of production, then feed is not only what measures the lien. The amount of feed that's purchased is a direct expense that could defeat your lien entirely, and so it would be nonsensical for feed to both be an element of the acquisition price and to be what measures and defines the extent of your lien. The other thing that Primebank did is they tried to rely on a North Carolina bankruptcy court decision, and even that doesn't get them where they want to be, because the North Carolina bankruptcy court, while it struggled mightily with the statute, was still drawing a dividing line between you have your acquisition, and then the North Carolina bankruptcy court was saying if this expense was incurred prior to acquisition, then we might consider an acquisition price. If it's afterwards, there's the North Carolina bankruptcy court did nothing like what they're asking this court to do, to say that every mouthful of feed until the date of the cattle or livestock are are slaughtered is considered to be an operating expense that's factored into this acquisition price. And so there's no case law support for what they're trying to do. It doesn't have any faithfulness to the definition of what an acquisition is. And when you look at the commentators in the Drake Law Review article that wrote on the subject in 1984, they noted that you might have a farmer with existing cattle that has no acquisition price. And so the Primebank makes the assumption that there has to be an acquisition price, but right off the bat, right after the statute was initially enacted in 1984, you have these commentators noting that that's not a valid assumption. There may be cattle that has no acquisition price, and that's what the court found here. These cattle were raised from birth. There was no acquisition that took place. There simply wasn't an acquisition price.
Ask you about the other side's plain language argument. I mean, we have this wording that says within 31 days after. Now, let's say I asked my son and I told him, you need to go brush your teeth within 10 minutes after you eat a meal. That usually wouldn't be interpreted to mean he could brush his teeth before he ate. You know, help me with that.
Help you with that. There certainly are sequences of events where sometimes you can't do something before. But when you look at revised Article 9, that's one of the things that revised Article 9 contemplates, is that you can file your financing statement. If it's an ordinary UCC, you can file your financing statement before you have rights in the collateral, before the security interest has attached. That's 554.9502 allows that. And then when you look at 9308, you have the same thing for agricultural liens, that you can file your agricultural lien and then it becomes perfected once it's effective, once the purchase is made. And so I understand the plain language argument, but I think where the plain language argument runs into trouble is that you have this as provided in 554.9308, and they just don't do anything with that section and the fact that it allows you to perfect your lien in advance of the time the lien becomes effective. And so I think that's where the plain language falls down, is that it ignores the as provided in 554.9308 language. Thank you.
Thank you as well, Mr. Voss. Owens Feed versus Primebank is then submitted, and we'll now hear the arguments in Des Moines Flying Services, Inc.